Good morning and welcome to the ODPP Café. I must first start by apologizing for delaying starting. We've had technical hitches, but I want to welcome you and thank you for joining us today. We are live on YouTube. Our Facebook page still has challenges and we're working on it, and I believe we'll be back soon. Karibu sana to the Café. It is a show brought to you by the ODPP, the Office of the Director of Public Prosecution. We bring this show to teach you and to give you knowledge about the criminal justice system. We welcome you to follow us on YouTube, subscribe, and engage with us also live on Twitter as we'll be posting what we'll be discussing today. So as always, I want to start with a few court cases that were highlighted this week on our side, and of course what has been happening at the ODPP. So just join me as I start on this. The first case I want to look at is about a man detained over family murder, quite a sad case. So Gishugu Senior Magistrate Law Court allowed the police to detain a murder suspect for 14 days to enable them complete investigations. I know we always ask a lot of questions about this. When somebody is detained, yet we know bail and bond is a right for everyone, but sometimes the court can allow the investigators to hold somebody in custody as they complete investigations, as is with this case. So Paul Murage Njuke is suspected of killing all his nuclear family members. It is alleged that Murage murdered his wife, Millicent Muthoni, and his 4 children, Nelly Wawira, Gifton Bundi, Sheromut Wamboi, and Clifton Njuki. Quite a sad case. So he's been detained to allow the police to complete investigations. The prosecution, led by Prosecution Counsel Kianyaga Museti, told the court that the police need more time to record more statements from the witnesses and search for the murder weapon used. Mr. Murage will be held until 15th December 2021, when the case will be mentioned. Quite a sad story there. The next case I'm looking at has also caused quite an uproar on social media about FKF President Nick Mwendwa. Mwendwa lost his bid to block prosecution in a 38 million fraud case. So Milimani Senior Principal Magistrate Eunice Nyoto dismissed Mwendwa's application to block his plea taking, saying the defense had not given sufficient evidence to block the charges. So Nick Mwendwa has been in custody and released because of this case that has been causing quite a story on social media and of course in the country about FKF. So Mwendwa pleaded not guilty to 4 counts of fraudulent acquisition of public funds amounting to 38 million. So the court granted him a 10 million bail with an alternative bond of 15 million and 2 sureties of similar amount. The case will be mentioned again on 20th December 2021. So we'll also still keep watch on that case. The next one is about the committee escapees. They get an additional 15 months jail term. A Nairobi court slapped the 3 terror convicts who broke out of committee maximum security prison with additional 15-month sentences. The 3 men, Joseph Odhiambo, Musharraf Abdallah, and Mohammed Abikar, pleaded guilty to charges of escaping lawful custody on November 15th. They were recaptured in Kitui 3 days later. I know you remember this because of the 60 million bounty that was offered for whoever finds them. So these 3 now have an extra 15 million jail term. So the 3 are to serve the sentence after completing their previous terms. Abdallah is serving a 22-year sentence after he was found guilty of plotting an attack on parliament. Abikar was slapped with a 41 jail term for the Garissa University attack in 2015 that killed 148 people. And Odhiambo was convicted in 2019 and is serving a 15-year sentence for attempting to join Al-Shabaab, the terror group in Somalia. So remember that story. It was prison break, Kenyan style, that took place in committee. But they were rearrested and now they're going to serve more time in jail. The next one, also quite a case that we discussed a lot as a country. Remember the woman whose hands were chopped off by her husband, Stephen Thenge. The court upheld a 30-year jail sentence for Stephen Thenge, who chopped off the hands of his wife, Jacqueline Mwende, in 2016. Justice Odunga dismissed Thenge's appeal that sought a lenient sentence since he was a first-time offender. Whoa. So the court still uphold this 30-year-old sentence on this man. The judge upheld the lower court's decision and dismissed the appeal by Venges, saying the offenses of causing grievous harm he faced are serious, which attracted a maximum sentence. So this guy lost his appeal and will still be in for 30 years. So finally, and this is going to be a segue into our discussion today, the ODPP this week launched a curriculum, Diploma in Public Prosecution's curriculum, and a Prosecutor's Guide to Children, a document here, a guideline to children document, prosecution for children, sorry. So the ODPP launched the Diploma in Public Prosecution curriculum and a Prosecutor's Guide to Children in the Criminal Justice System at PTI grounds in Loresho on Tuesday this week. So the first document, the curriculum, aims to provide training for newly recruited prosecution counsel and any other person who meets the basic requirements for admission on the diploma course. I think, quote unquote, it has to still be a lawyer who maybe gets admitted to this. I mean, if you want to be a prosecutor, then you have to go to PTI and be trained on this using this curriculum. So the Prosecutor's Guide aims to assist prosecutors handling cases involving children who come into contact with the criminal justice system. And like I said, we are going to discuss this today. So key policy documents that have also been developed in the recent past include the decision to charge guidelines, the plea bargaining guidelines, the diversion policy guidelines, and deferred prosecution agreement guidelines. These policy documents intend to professionalize prosecutions and provide standards that will apply across the country when it comes to prosecution. So like I said, this is going to get us into the discussion today, but before that, please have a look at this video.
Today, we launch our Diploma in Prosecution, which document has been developed by the help of our development partners. The purpose of the Diploma is to professionalize prosecution services so that we be responsive to the emerging crimes, emerging issues, and emerging developments in prosecution all over the world. Secondly, today we launch a guide in prosecution of children cases for purposes of predictability, transparency, and professionalization of decision to charge in dealing with children. These two documents reflect one of our strategic objectives to make prosecution services professional, civilized, and also to make prosecutors be part and parcel of the objective of the whole country, that we be people who obey the law.
When we went to some of the courts, we noted that we are handling children's matters in a very, different way. A prosecutor for instance, in a county like Kisumu would handle cases of children very differently. Yes, we were respecting the children's rights, but we needed a tool which was going to give us uniformity so that when we even present ourselves before the courts, we are able to know that this is the manner in which the prosecutor in Makadara is handling a matter, so this is the way I'm supposed to handle a matter. A team of very talented prosecutors headed by Karimi sat down and brought out this space, and they talked about having children being handled the same. So for me today, it is a journey which has been walked by the Office of the DPP through this unit, which has been very, very vibrant and ensuring that we get these children. The children who sit before us, we are there to ensure that we protect you.
I would like to also personally thank you today for taking the issue of child protection seriously and spearheading the work with these guidelines, but also with the diploma course in public prosecution. I want to
Today, we launch our Diploma in Prosecution, which document has been developed by the help of our development partners. The purpose of the Diploma is to professionalize prosecution services so that we be responsive to the emerging crimes, emerging issues, and emerging developments in prosecution all over the world. Secondly, today we launch a guide in prosecution of children cases for purposes of predictability, transparency, and professionalization of decision to charge in dealing with children. These two documents reflect one of our strategic objectives to make prosecution services professional, civilized, and also to make prosecutors be part and parcel of the objective of the whole country, that we be people who obey the law.
When we went to some of the courts, we noted that we are handling children's matters in a very, different way. A prosecutor for instance, in a county like Kisumu would handle cases of children very differently. Yes, we were respecting the children's rights, but we needed a tool which was going to give us uniformity, so that when we even present ourselves before the courts, we are able to know that this is the manner in which the prosecutor in Makadara is handling a matter, so this is the way I'm supposed to handle a matter. A team of very talented prosecutors headed by Karimi sat down and brought out this space, and they talked about having children being handled the same. So for me today, it is a journey which has been walked by the Office of the DPP through this unit, which has been very, very vibrant and ensuring that we get these children. The children who sit before us, we are there to ensure that we protect you.
I would like to also personally thank you today for taking the issue of child protection seriously and spearheading the work with these guidelines, but also with the diploma course in public prosecution. I want to tell you that I am personally very committed to the cause of child protection. I hope that the guidelines will be used all over the country to make sure that we have uniformity in handling juvenile cases all across the country.
The Prosecutor's Guide to Children in the Criminal Justice System, which was developed with the support of the European Union and UNODC, sets out what is expected of all prosecutors when dealing with children in conflict with the law and children who come into contact with the law. Children, whether in conflict or in contact with the law, have a fundamental right to be protected and treated with dignity. In addition to the guide, the ODPP has put in place measures to ensure that children's agenda is at the forefront of our operations. In this regard, the ODPP has set up the Child Justice Unit within the Children's Division. This unit is made up of prosecutors from all the different counties. It is intended to enable a fast response to children issues. Other interventions that have also been adopted in furtherance of children's justice include setting up of child-friendly interview rooms in 7 counties, namely Nairobi, Nakuru, Mombasa, Kisumu, Kiambu, Kajiado, and Lamu. They will be equipped with video conferencing equipment to allow for remote interviewing and court sessions, thus minimizing secondary victimization of child victims.
And for that, we thank you for coming this morning to be with us to launch those 2 documents.
Tunaahidi mashtaka yenye haki na usawa.
Thank you so much. What you have been watching is what took place on Tuesday when we launched the Children's Guidelines, the policy document for how prosecutors should handle children cases. And it was quite an interesting launch that, as you can see, was graced by, amongst others, the EU ambassador to Kenya and other guests. So today's discussion is about the Children Guidelines. And I know we've talked about children and the law, I think twice on this show, but clearly it's not exhaustive. We cannot completely finish talking about children. And how we say it on the ground, kazi ya mtoto ni kulea. So even in the criminal justice system, they also do the kulea part, and that's what we want to discuss today on how they intend or how they want to handle children going forward. So before we start, as always, I want to ask my guests to introduce themselves, and then we can definitely start the show. And we are joined on Zoom by Justice Madeka, and I'd like for her to introduce herself to the viewers. Karibu, Justice. Judge, kindly unmute. We can't hear you. We can't hear you. Please unmute. She's still muted. We can't hear you, Judge. If you can unmute yourself. Let's see. I can't unmute her. There you are. So if you can just take it up again and introduce yourself. We didn't hear you the first time. Good morning, Judge. Can you hear us? Good morning. Good morning. Can you hear us?
Yes.
Kindly introduce yourself. We didn't get to hear you the first time.
Good morning. My name is Teresia Mafeka, Judge of the High Court of Kenya at Nakuru. Currently, I am also the chair of the Special Task Force on Children Matters that is housed by the National Council on the Administration of Justice.
Karibu sana to the show, Judge. And I must add to our viewers that you are the one who made some good ruling about housewives doing full-time, should be considered as employees full-time. And that the 9 months of pregnancy should also be considered as time spent doing something. So I hope our employees and employers got that bit. Yeah, it was quite a good ruling for mothers and us as well. So we just need to understand how to put it in our CVs, that we were busy doing other things. Thank you so much. Karibu to the show. I'd want Caro to introduce herself. She's not new, but it also helps that for the new viewers, for Caro to introduce herself. Karibu sana, Caro.
Thank you very much. My name is Karimi, and I'm a prosecutor at the office of the DPP. I head the Children's Division and the Anti-FGM unit. It's a pleasure.
I am not hearing Caro.
Oh, sorry.
Oh, let's try again. Yeah.
Yeah, good morning, everyone. You can hear me now, Judge? And viewers, thank you. My name is Karimi, and I'm a prosecutor at the office of the DPP, where I head the Children's Division and the Anti-FGM unit.
Karibu sana. I don't know whether you heard her, Judge. Did you hear her? Did you hear her?
No.
Technology. We are checking on the sound, but as we check on the sound, like I said earlier, the ODPP launched the Children's Guideline, a guideline that shows prosecutors how to handle children that come in contact with the law and in conflict with the law. And we've discussed this before about the difference between the two. And maybe I'll ask Caro to again start by telling us the difference between a child who is in conflict with the law and in contact with the law, for the sake of this discussion today.
All right.
Yeah.
Yeah, so these are the two children that we find in the criminal justice system. The child in contact with the law is a child who comes into the justice system by reason other than being a child who has committed an offense. So we are talking about a child witness or any child victim. By victim we mean a child who has had an offense committed against them, or some vulnerability has made them to come into the system.
Yeah.
So those are the children in contact with the law.
Yes.
The one in conflict with the law is the one who has committed an offense. So they have been brought into the system for the purposes of being rehabilitated.
So this guideline takes care of both?
It does take care of both. In fact, we have made sure that each of these child has their own provisions, two distinct provisions within the guideline.
Okay. So, Judge, I just wanted to ask, before we get deep into unpacking these guidelines, where were we before these guidelines came to pass, that before they were drafted, for example? And maybe you speak now as the lead from NCAJ who was dealing with the children guidelines.
Thank you very much. One of the things that I need to point out here is that we have the laws in place. Every agency in the child justice system has the laws. Their statutes are in place. But when it comes to the actual nitty-gritty of how to handle a matter in court, that's where the challenge now comes in. Because it's that point that this particular person will want to know what steps do I need to take when dealing with a child who is in conflict with the law or who is in need of care and protection. So before these guidelines, I think everyone was just doing what they think is right. And you can imagine what that means, that it depends on the prosecutor or that a particular person on what they understand the law to say and what they think, how they think they should do deal with a certain child or a certain case. So these guidelines coming now, I think standardizing how we handle it so that any child, whether they're in Kakuma or they're in Lamu or they're in Nairobi, they can expect the same standard of treatment. But before these guidelines, I'm sure Madam Karimi and other prosecutors will agree with me. It was just how each one understood how to deal with every case that came before them.
So it was on case-by-case basis?
Yes. And also depending on the person.
Okay. Okay. So how long did this take? How long has the journey been since you decided to work on the new guidelines? Judge?
ODPP can say how long it's taken them, but since we had the Children's Act,
Yeah.
and there have been no guidelines, even since the Constitution. The Constitution created ODPP, created all these other agencies, but there have been no guidelines on how to deal with it. So it's been a journey.
Okay.
It's been a journey. The task force came into place in 2016, and that is the point where some of these gaps really stood out.
Okay.
And what to see how we can fill in the gaps.
All right.
Yes.
How long has it taken ODPP to come up with the guidelines, Carol?
So it's been a journey that started in the year 2019.
Okay.
Of course, we appreciate that 2020 COVID came and really stalled a lot of progress. Yeah, but the inception of the thought of having guidelines, a framework which can guide the prosecutors, was in 2019. So we can say it's been a journey of 2 years of a lot of work, because for us to have come up with this guideline, we had to go to the ground, meaning we have gone all the way down to the sub-counties to find out the needs assessment, what are the gaps, what are the challenges, and the strategies. That is what now created that framework, and then we fleshed it up. And it's been a journey involving ODPP and all the stakeholders in the child justice system.
Okay.
Yes.
Who are your sponsors? Because clearly you did, like we saw on the launch, it was just not ODPP alone.
Exactly.
Yeah.
So UNODC has been a very big support, not just to the Children's Division, but to ODPP at large. So UNODC works under the EU plead program. So they are the ones who have supported this journey. They were able to give us the technical expertise because they gave us a consultant who guided us in how to prepare a good policy, because we are prosecutors, we are practitioners.
We're lawyers.
Yes, we have the knowledge, but we don't have the expertise of doing a policy. And then they were able to also give us financial support, because this included consultative forums where we had to host other stakeholders like members of the NCAJ, the police, and every other person who is very key and who processes the child through the justice system.
Are children part of your stakeholders?
Yes, they were.
Oh, really?
We had forums with children. We had to ask them what they thought about the justice system and what they saw as the problem and what they propose that we should do. We did.
That's interesting. I didn't imagine you involved children in your discussions.
They do, and in fact one of our key principles in the guide is child participation. So
Okay.
we had to implement that even in the guide.
Start from the guide.
Yes.
Yeah, okay. So as we get into this, I just wanted us to clear out the age of criminal responsibility. I mean, in itself, it's contentious. So what is your take about the age of criminal responsibility?
All right, so the current age of criminal responsibility for a child is 8 years. Basically meaning we cannot prosecute a child who commits an offense who is of the age of 8 years and below.
Yeah.
And then there's another limit of any child below the age of 12 is presumed not to have known what they're doing. So we have to rebut a certain presumption before the law can allow us to prosecute. So I think 8 years is, even a 9-year-old child, a 10-year-old child still doesn't really understand what they do. And so we really haven't addressed it in the guideline for one reason. The guideline is actually a policy document that derives its authority from existing statutes.
Okay.
So we have to work with the existing law, which says 8 years. But there's a children's bill, which is in Parliament right now, which is looking at increasing that age of criminal responsibility. And I don't know, Judge can remind me, I think it proposes to increase that age to either 12 or something, I'm not very sure. But if it goes through, we could be looking at, not prosecuting children from that age of 12 years.
I don't know, Judge, what do you think about the age of criminal responsibility when it comes to children? There's been discussions in different quarters that it is contentious and it should not be what it is right now.
Let me begin by saying that I agree with Carol that, that first of all, that the age right now, the minimum age of criminal liability is 8 years old. So you can just imagine any 8-year-old, any that your child or your nephew or your cousin or just any age, that if they committed an offense today, they can be charged and brought before a court of law. And we are saying that really Kenya as a country, we need to move from there. We need to understand child development and see whether at that point we really have to drag a child to court. And the proposed age now, minimum age is 12 years. So if the bill goes through as an act of parliament, then we will have been saved from that situation. It shouldn't be it should be contentious because we should be able to get help from the people who deal with child development. They can tell us that a child of a certain age will not necessarily understand that what they were doing is wrong. So we look forward to that.
Apparently it's the lowest in Africa, so we really need to be progressive like we are with our constitution and maybe increase that age. So what does child-friendly justice mean, Carol?
Okay, so a child-friendly justice system is one that is very sensitive to the needs of the child. So we do agree that we have children in the justice system, which is very unfortunate because we all remember ourselves as children and how mischievous we are, and some of that mischief bordered on criminality, right? So we are saying that there's this vulnerable group of people who come into the justice system that require special procedures and treatment. And what we are currently, the voice we are all giving as especially NCHA and the Special Task Force on Children Matters is that we have to have a justice system fit for the children. So we're talking about a system that understands what are the needs of the child and how can you, address those needs in a manner that protects the rights of this child. And then just appreciates the vulnerabilities and the developmental challenges, as Judge has said, of this child. So we are talking about a system that looks at the mental needs of this child, the physical needs of this child, just the welfare of this child. And one example, just to give a picture of what a child-friendly justice system is, is one like the one we have at Milimani Children's Court, where we have children coming to the court, but there's a playground.
Oh.
Right? So
it doesn't matter whether in conflict or in contact with the law.
Yes, you see, a child coming into the justice system does not stop them from being a child. So we must allow them to continue being children even while they are still within the justice system. And maybe just to draw attention to like the guide that we have, if you're able to see, the front picture we have here is a playground. Children are on the swings, they are on the slides. There's the office of the DPP, there is the children's office, there's the judiciary. So we are basically saying this is a justice system, but it must be fit to the developmental needs of the child, because this child is still continuously developing even while we are still in the system. So it must be fit to the child in every sense of that way.
I'm wondering, Judge, with such a nice system for children where there is a playground and all that, don't you get worried about repeat offenses? Because maybe a child will feel like I'd just rather be going back there every other time, because maybe I have a bouncing castle, there are teddy bears to play with, I can color, I can maybe eat what I want to eat in as much as I'm still in the system. So Judge, do you think that may just encourage repeat offenders?
Let me just say this.
Yeah.
First of all, you asked about, I can't hear Carol very well. I'm still having sound problems on my side with her voice.
Okay.
I don't know what the problem is, but about what is a child justice system? What do you expect from a child justice system? Let's just begin by saying, of course, we are the agencies ourselves, but there are the laws and the norms and the rules and the regulations and the guidelines, all these things. The infrastructure, it's not just about people and laws, but even the infrastructure. Because the idea behind a child justice system is to rehabilitate this child. All our communities, if you think about it, children were always assisted to change if they had gotten into bad behavior, and things would be put in place to enable these children to change. The justice system is based on the same principles, that when a child comes into conflict with the law, one of the things that we should be alive to is that somebody somewhere has let go, because children should not find themselves in the system, in the justice system. So all these things being put in place is to enable us to change this child, to get them to be better before they get into the adult age, to have a system that does not cause harm, but enables the child to change, to be rehabilitated, to change whatever it is that is making them come into contact with conflict with the law. So all this is not intended to make them feel that the system is nice to them. I don't think any child enjoys appearing before a judge, or enjoys going to the police station, or enjoys being within the court premises. But this just may enable them to that space where they can tell their stories and be able to be heard, and be able to make a determination that is good for them.
Good for them. So where does access to justice begin for the child? Where does it, when you talk about access to justice, where does it begin for the child?
I think it begins, the cycle of a child coming into the system is the first time they come into contact with a certain event. So if it is a child in conflict with the law, it is the minute they commit that offense and they're apprehended. That is when access to justice is supposed to start, not at the courts. It has to start with the first responders. So if it is a child who has committed an offense, the first responders will be probably the community. And then they will call in the police. So the community are the first place where access has to start. Yes, the first responder. And it has to be a continuous journey without any break in that link, up to the time the child is reintegrated after having been rehabilitated.
The cycle has to complete.
It has to be complete, because if it breaks, if we stop we have rehabilitated the child, but we fail to do proper reintegration, we'll find that child back in the system.
Okay, so I'm wondering, when we talk about access starting from the community, what are we doing anything to bring all these people on board? Because clearly it's just not the judiciary and the prosecutors, but now there's the community, there's the police, and all these people on the chain. What are we doing to bring them on board?
All right.
Yeah.
So I will give a good example, which, and I think I will want maybe Judge to build on, because she was one of the people who started the issue of court users committee.
Okay.
So every court station has a court users committee, and it is made up of every person who is in the criminal justice system, including the community. Okay. So in some of these CUCs, we even have the Nyumba Kumi represented. So these are people who then will be sensitized on being first responders. What does it mean? How do you safeguard the rights of that child when you first apprehend them, or you first come to know that an offense has been committed against them? And then in these CUCs, we also have like the NGOs, the CSOs, who are able to go down into the community and do a lot of trainings together with the other stakeholders. So we have those forums, the court users committees, the area advisory councils, and then we have training and sensitizations that can be organized jointly as stakeholders. Like NCAJ has been doing a lot of work on that, or even individual institutions like ODPP. You have seen us go on the ground and we call the community and we sensitize them on the rights of children in the system and all these other people. Yeah, and we even use media. And even this is another forum.
This is another forum.
Yes, we are sensitizing the community.
Yeah, Judge, I don't know what your thoughts are about bringing all players on board. Is that happening? Is it possible that everybody can be on board, creating a child-friendly system?
You are actually doing it right now. That's one thing that you're doing right now.
Okay.
By having this forum and raising awareness on, for example, what the ODPP does, and asking us these questions. But I think I didn't hear very well what Madam Karimi said, but I want to just rein in on that we have the court users committee. Court users committees include the children court users committees, where members, people who use the children's court, are able to give feedback to court. And these committees also do outreach. They go out there and meet the public and talk to them about issues of children. The area advisory council, that I had that mentioned, where members of the communities are members, and these are the same people again who have the duty to raise awareness about the rights of children about the community. Then we have, like now, the task force have the service month. This time it's running to December. During this time, court users committees, and the ODPP is a member, a very prominent member of the children court users committees and the task force. They go out and again, in their jurisdictions, have public meetings. COVID has made it a bit difficult, but they are able to do that during the launch of their service weeks. Members of the public are invited, and that's one stage where people can speak about these issues. Then there's child participation. All these things that we are doing, children are brought on board in different ways. You get their views on what they need. For example, just before the Day of the African Child, children all over the country were brought on board through forums, an online forum, virtual forum like this, where they met different policy makers, including from judiciary, from government, and ODPP was there. The office of the AG was represented. The office of the registrar of banks was represented, and children posed very serious questions. And what does that mean? It means that they are aware of their rights, and we are also encouraging, raising awareness among them about their rights. Similarly, on the day, International Day of the Child, 20th of November, children had the opportunity, both virtually and physically, to meet again with policy makers. I was there. The ministry where the children's department is housed was present, and various other organizations. And again, children were able to meet and discuss this particular issue. So what am I saying? That bringing other people on board is something that's going on. It's a good thing that we have this forum, and again, the children are able to understand, know that they have rights, they have rights, and they can hold us accountable.
Oh, okay. That's quite interesting.
Everyone is coming on board. Pole pole.
Pole pole, yeah, it can be instant. I hope you also plan to go to schools, to primary schools and high schools to teach them about this. I think that the right of the child came out recently when children are banning schools, this banning of schools. And everybody kept saying arrest, charge, and jail them, you know. And I discovered not very many people understand that we are talking about people who are below 18. So in spite of what they have done. But the law still says something about that, right, Carol?
Yes, it
Yes,
does.
yeah. Okay, so just into the document now. It talks about some guidelines, some guiding principles. And one of them is the best interest of the child. What does that mean, Carol?
The best interest is as wide as any case you can think about. What I mean to say is there isn't really like pointers that you can say this is a best interest that should apply across the board. Best interest is, this is a child in front of me. They have done 1, 2, 3. What is their background? What is their level of development? What are the challenges they are facing causing them to come into the system? What is the best way to rehabilitate them? So you see, it is really so many factors that really talk about the child and have a focus on the child. I wanted to say itself, but the child herself or himself.
Yeah.
So it is all these factors that actually enhance, safeguard, and protect the rights of this child, and that ensure as they go through the system, they come out of it better than they left. Yes, so it is really very subjective. It is from one case to the other. The age of the child will help you as a prosecutor to say, this is a very young child, this is what I'm supposed to do because these are the needs of the child, which would be very different maybe from an older child. And even the environment, a child in Nairobi, a child in Lodwar have completely different needs.
Yeah.
But best interest is basically a stop and just telling the stakeholder, wait a minute, you're dealing with a child. Before you make any decision on this child, you have to ensure that that decision does not infringe or violate any of the rights, does not, is not detrimental to their developmental needs. It is just the best way to handle this child because we understand that they basically are a child.
Yeah, but then, Judge, I'm wondering, when looking at this best interest of the child, there are so many checks that you have to make. Do they not make the case drag longer? Or are there, what happens in such cases?
Best interest is a very subjective test because it's the circumstances of the child in front of you as you are dealing with the matter. Weigh what is needed for their welfare. If the child is in conflict with the law, they need to go to school. Their life does not stop. They need, they still need, if they are unwell, they still need to be treated. And all those kind of things. Like basically, how do you take care of their welfare, and also how do you ensure if they've committed an offense that they are put through a system where they understand they did wrong and they need to change. And if there's that there's a punitive side of it and there's the rehabilitative side of it. It doesn't make the case drag. We are required to look into every aspect of this child as we go along. And because it's not a single person doing it, everyone does their job. Let me give you a small example. If the case is in court and you need to determine a certain issue to do with the welfare of the child, for example, maybe they need to go back to school, you get a report from a children's officer, you see. And this is, the court will ask for it, and because we are all aware that we need to do this quickly, the report will come and the court can make that recommendation. If it's for diversion, like you learn later in the program, I'm sure, they get a report from the officer and they say this kid actually will be better off going back before they even enter the system. So because we work together as a team, because this, as you heard from Karimi, it's a cycle. We all work together as a team, dealing with the same child, then we are able to look at this quickly and be able to move. The issue of best interest does not make the case drag. It's other factors that make the case drag. The best interest of the child does not
make the case drag.
That we have to do from the point. Yes, it doesn't. It doesn't.
Okay.
It's when many other factors will come into play.
All right.
Okay. And Anita, if I may add, in the guide, one of the ways we have put there as a way of the, like guiding the prosecutor on how to ensure the best interest is catered for, is to have a care and protection file opened for each and every child, because that is where you will know what are the needs of this child.
Yeah.
Yes.
So it's called a care and protection file.
A care and protection file.
Oh, okay.
Yes.
So Carol, tell me, what happens when you walk into court and you find that the child seated there is not represented?
Yes, and that has been a very big challenge.
Yeah.
It made us as an office to stop and really interrogate what we were doing. Because we have all seen these TV programs, Vioja Makamani,
Yes.
and we have a picture, even if you have never been accused of an offense, we don't know Anita. The whole procedure of court is very complex to everyone. In fact, for us, we have had to go to school. We have to do a degree.
I'm going to court, I'll freeze first.
Yes, everybody
afraid.
freezes. It is a complex system. Now, you can imagine having a child in that complex system all alone, pitted against a seasoned prosecutor. I am not calling myself a seasoned prosecutor, but I am a trained prosecutor.
Yes.
So it is like a match. It's like having a sumo wrestling where you have this big guy and a very small person in a ring, and they're supposed to fight
a fair fight.
And you expect to call that a fair fight. So we saw that as unfair. Why should a child have to be in a system so vulnerable because of their developmental stages? We all know children are still growing. Their mind is still growing, their emotions and all. So that made us come up with the practice directions, first of all, to get the prosecutor that we have these sections in the Constitution, because the Constitution does guarantee accused persons right to a legal representation if there will be substantial injustice. Right? We have the Children's Act talking about if there's a child in the system, they should be given legal assistance at the expense of the government.
Oh.
Yes.
So it can be free. It's free.
It is supposed to be free.
Okay.
Yes.
Okay.
And we have many courts that have already taken up. One of them is the court in Nakuru where a judge sits. We have Milimani, but unfortunately it is not everywhere. So we as an office have made a stand that we will not proceed with these cases. Cases where a child does not have legal representation, and we are being guided on what to do. We're supposed to make an application to the court and request for the child to be given legal representation at the expense of the state.
So that is also provided in this guideline?
And the guide also provides that. And I know even judiciary did send out practice directions to all the courts, informing them that there is need to have these children given legal representation.
Yeah. Judge, I don't know what you'd do if a child came to you without representation. Would you continue with the case? Have you ever continued with a case that had a child who had no representation?
Let me tell you that before this current situation where we have representation for children as a matter of course, I worked, I think, in Kibera and other courts, and I think the case that turned out for me was a case where in Kibera where a young boy was charged with robbery with violence.
Yeah.
And he was about 15. He had been shot by the police, he had been in hospital, and when the case came before me, he had just been released from hospital, and when I called out the case, he started crying and opened up his shirt and showed me his scar and said, telling me how I was shot by the police, they charged me with this offense, and he didn't have a lawyer. So you can imagine how you feel. You are sitting there and you have this young boy. And I tried to get people to represent him. It was difficult. Luckily enough, we had just had the Constitution, it was in 2011, I think. And I remember writing to the Deputy Registrar at Milimani Ben to ask that please give this boy a lawyer, because you see, murder suspects will get a lawyer as a matter of course. So mine was to just ask, can we get a lawyer for this boy? Because I don't see how we can proceed with this case without an advocate. Unfortunately, I left the station because I couldn't proceed before the matter started. Because I said I can't proceed with that without it starting. In other stations, what we did was try to get pro bono advocates to represent the children. We literally begged the advocates, please sign up to, and they did.
Yeah.
In Nakuru they did, but in Nyahururu and they did. Because as I'm saying, it's very hard to have a kid representing himself.
Yeah.
So we are glad that now we have that guidance that every child who appears before a court must be represented, and the guidelines are clear. So I'm not sure any prosecutor will start prosecuting a kid when there's no advocate for that child.
Yeah.
The guidelines are clear. Yes.
Yeah, that can be interesting. Yeah.
They are going to be in the past.
Okay. In the guideline, it talks about right to privacy. What does that mean? What does that entail?
Right. So, right to privacy for a child is basically meaning that the identity of the child should not be disclosed to the public. The reason why we say that is because, first of all, the Children's Act is very clear in Section 76. It says name, identity, or any other information that will disclose who this child is should not be disclosed. So there is that statutory provision. The reason why that is important is because we understand who children are. They're in the system because, you know, they are still growing up, they are making mistakes, and there's a need to give them a second chance. So we do not want what they did in their childhood, or what me and you, Anita, did in our childhood, to follow us into adulthood where we have already now developed. We're saying this is a special chapter of every single human being. We are vulnerable because of our development as children. So that should be protected. It should be a chapter that should be opened, rehabilitate the child, close it. The child is rehabilitated. So as ODPP, what we are basically saying, because we have the decision to charge, we draft the charge sheets. Start there. Hide the identity of the child. So put initials of the child. So if it is Caroline Karimi, on this day committed an offense, say CK. So that anyone, because a charge sheet is a public document, taking that charge sheet can clearly not be able to recognize it is this child who has committed this offense. Judiciary is way ahead of us, because judiciary for the longest time in their judgments, in their cause list, will always use the initials of the child. So that is the right of privacy we are saying, because we do not want this life of childishness and childish mistakes to really affect. Yes.
What do you think about, still back on the school fires? A lot of these children, their photos were pasted on social media by other agencies and other actors, including the public, just saying Anita is there, she burnt the school, arrest, charge, jail. What happens?
Anita, I think we'll start charging those media houses because they are infringing the law. I think Children's Act is very clear. But the sensitive media houses will always conceal the face of the child, will always not put the real name of the child if they have to give the story. It is a good practice that is not just in Kenya, internationally. The Convention on the Rights of the Child, the African Charter on the Rights and the Welfare of the Child all talk about that need to just, let's protect these children. You know, they are 100% of our future. I mean, 100 years from now, Judge and yourself will not be here. Who will be here? It is these children.
It's them. I think social media has made it worse as well, because everybody is a journalist. Everybody wants to break news, and sometimes it just means their photos are pasted on social.
And now that you have spoken about that, because we know we have these good gadgets, the phones. And we get these clips of children in bad situations and we forward them. I think it is important for the public to know that there's the Cybercrime Act, and you can be individually charged for forwarding, you know, a video or a picture of a child.
All right. Judge, I don't know what you have to say about, there's something in the guide that talks about deprivation of liberty as a measure of last resort. What does that mean? I mean, maybe in simple terms, because this show is for people like me who are not lawyers. So what does that mean? Deprivation of liberty as a measure of last resort.
Okay, first of all, what does it mean to be deprived of your liberty? It means that your freedom to move around is taken away from you. So that means you are confined, legally confined somewhere. So what happens is that children may be confined because of the offense they have committed. But what that guideline is telling us is that that should be the last thing you do. Because we have institutions for confining children. We have the remand homes where a child whose case is pending can be confined pending the hearing of their case. But to apply that principle, it means we must find, give that child a bond. If their parents are not available, can we find someone else who can live with that child pending the hearing of the case? Can we find another way to ensure the child does not stay in the remand home? Then there are rehabilitation institutions where they're supposed to be taken after the case is over, like the rehab schools or the postal institution. But we are being told, let us try community rehabilitation programs before we send them to those institutions. Let us take the child who cannot stay in the community there, and not, not just every child. So that is exactly what we are being told. And it's not just in the guidelines, it's a constitutional edict that children should be kept in those places for the least time, only if necessary. So that is what we are being told. And the fact that it's being told to the prosecutor is that the prosecutor can actually also contribute to attending the court room. This child will not go to the remand home. They can be given a free bond. This child, from what we've seen, can be diverted. This child does not have to go to the rehab school. We can find something for them in the community. So that's what we are being told.
Okay.
Let's not take children in this system. Let us send them to the community for rehabilitation.
So when you send them to the community, you're taking them back to the village, to their families for rehabilitation or what?
Yes.
Yes. But under programs.
Yes.
Oh, okay.
Yes.
Okay. Oh, interesting. So the family still holds a place when it comes to child justice.
Wow.
Yeah.
Anita, I will tell you, in our work as prosecution, we have discovered one of the reasons we have children in the criminal justice system in the first place is because of the family breakdown. That is where the problem starts brewing before it becomes big, and then the community cannot address it and it is brought to court. Long time ago, the community used to address these issues. If the child did a mistake, they would be taken to the community, and anyone could be this. Exactly. And the child would be, rehabilitated within the confines of the community. But when that fails, that is when they come into the justice system. But we are saying the justice system really isn't the best place. It should be the last place to take this child. So even if they come to the justice system, we can still find a program that can allow them to be rehabilitated in a community. You know why? Because we need this child eventually to go back to that community, to reintegrate and to grow. So it is the best place to rehabilitate this child.
But then you still find yourself as a prosecutor making the decision to charge in children cases. Is it any different from how you make it for adults?
Yes, it is different.
How?
First of all, by understanding that you are dealing with a child. I mean, a child is not a child just because the act says anyone below the age of 18 is a child. There is science behind it. So there is, the developmental milestones of a human being begin at birth, and they go all the way up to old age. You continue growing until old age.
Yes.
So there is research that anyone below the age of 18 is still growing psychologically, emotionally. Their judgment-making process is still developing, so it is challenged. The emotions are still developing. That's why when a child is hungry, what do they do?
When a child is hungry?
They cry.
They cry.
Do you cry when you're hungry?
No.
No, because you have developed, your emotions have contained themselves, your judgment is better. Yeah? So these children are children because research has shown that they are children. So when we are charging these children, we have to take that into account, that maybe they committed that offense for not knowing better. Maybe the parent has failed to teach them, because parents must understand they have a sovereign duty and a sacred duty to train this child. So because the child is there, not entirely out of their fault, we must treat them differently. So the diversion guidelines is guiding the prosecutor to always consider alternatives to prosecution when dealing with a child. So that now we are only taking to court the ones who cannot be diverted. Maybe they are repeat offenders, maybe it's a very serious offense, etc.
And I wanted to ask, in as much as we're talking about not taking the children through the system, we still find ourselves in the system. Yeah, so they still go to trial. So what happens, Judge, when you get a child who's come, who's been brought to you for trial? First of all, I ask, how do we get there? Because we have all these restorative options, but we still find ourselves there. What actually makes a child reach the dock, if at all I can use the words?
You see, the ODPP now, as we've seen, they have these guidelines for diversion where the child can be diverted before the matter is brought. But sometimes the offense would be serious. For example, they cannot divert sexual offenses. For example, if a child has committed a sexual offense, and here we are not talking about the Romeo and Juliet cases. There are those cases where they say you're almost age mates, and maybe you agree to do this thing, it's wrong. So what you did is wrong, but we can't prosecute you for it. We try and cut so that you understand why. So imagine that child who had defiled, maybe he's 16 or 17, and defiled a 3 or 4 year old.
Yeah.
That child will be up through the system for us to find out why did you do this, what can we do to it, because that's really, it really looks criminal already. So taking this child through the system so they can understand the wrong they did, and for us to find how to rehabilitate them. And maybe as they go through the system, we also get a chance to investigate the home. That's another opportunity we get. What is going on in this home that this child can commit such a crime? So that, that is, they also, there's those that assistance that comes through the PNC file. Children who commit serious crimes, they commit serious crimes. They commit murder, they commit terrorism offenses. Those kind of children, you find that they end up in the system because it might be difficult to actually divert those cases. We may need to take them through the system so that we find what the problem is and apply all the, there are other, they call them treatment plans by the other agencies. So they can apply those treatment plans, those treatment procedures on these children to help them to change. So that's how they end up in the dock when we cannot divert them.
Okay. Still at the trial stage, there's something in the guide that says disposal of cases. What does that mean, Carol?
Disposal of cases is just basically, dealing with these cases to the logical conclusion. So it's just getting, the prosecutors how to do it in a child-friendly manner. Yes, because unfortunately, we some of these children, like the judge says, have to go all the way up to being committed into, sentences. Yes.
Okay. Judge, maybe just again, because this is also a very educative show, what is priority hearing? I read it in the guideline and I was wondering, what is priority hearing?
One of the things you will know, Anita, is that courts have so many cases, every day a cost list run into, like in the lower courts, or maybe you can go to a magistrate's court and then they have a cost list of 20 cases. Yeah. Or in the high court, similarly. And you see, all these cases are competing for space to be heard. Everybody wants their case to be heard. As much as we ask people to try mediation, negotiation, all these other things to keep the cases from court. So what this means is that when a children's case comes to court, we need to put it on top of the list. Okay. Why? Because we have rules that tell us also that a children's case will end within 6 months. Why? For as long as a child's case is in the system, the child is waiting to be heard as a child offender or a victim. What does that do to them? Their life kind of just drags down because they have this unfinished business. And if they are being held in an institution, maybe their education has been curtailed, you see? So for us, it is in the best interest of the child for us to complete this hearing as quickly as possible. So when they say priority hearing, it means the prosecutor will place before the court this information that please, we need to finish this case within 6 months, put me on top of the list, even if I came yesterday, place this case in the list for us to be able to proceed with this case and finish it in the required time so that the child can continue with their lives. Yes, so that's what it means. Okay, yes. All right.
Yeah. And maybe to add on that issue of priority hearings, there is in the system we'll have victims of criminal offenses, and some are very young. I think my youngest witness was 3 years old.
Witness?
Yes, a victim actually of a crime, and she had been defiled by the father. So this is a child who's very young and very likely to forget what happened.
Yeah.
So if this happened yesterday, she'll recollect for you very easily. But if you give her a hearing in 6 months' time, that child will not remember the time, the day, and exactly. So to preserve that evidence, so that we ensure that this child gets justice, we have to have that child heard as soon as possible. If possible today, if not, in the next few hours.
Yeah.
Yes.
Ah, okay. So even when you talk about children, yeah. Yes.
But if I can just add to that, about there's the victim who has been offended, and sometimes they are very young witnesses who are the ones who witnessed the crime.
Yeah.
So you can imagine if a child is very young and that they've seen something. As the day goes, as days go, their memories are mixed up with other things.
Yeah.
And a psychologist will tell them, you want to forget that thing, and they ask them more and they can't remember, or they simply won't want to talk about it.
Yeah.
So the prosecutor placed before the court all the necessary information so the court can, give them that priority hearing. So both witnesses and victims, yes, and vulnerable witnesses as well, yeah.
Okay. I had to speak about free bond. So bail and bond, is it different from what we give to adults? Judge?
Oh, look, the bail and bond rules are the same.
Yeah.
Are the same for everyone. The only thing is that when it comes to children, you go, there's this, you go to another extent. Because, for example, when a child is arrested, the OCS at the police station is required, for example, to call the parent or a children officer, or if there's a pro bono advocate, to the police station. So that means the OCS can release this child to this person to go home with, and the child can come back to court. Now, when the child is brought to court, if the parent is in court, because it is the child can't pay cash bail for themselves or anything, the parent will be assessed if they can take the child home and bring the child back to court. You see, so the court has to go to those other lengths, but the goal, the law is the same for everyone. But when it comes to actually assessing children for bail, you look at the best interest of what is the best interest of this child in this particular situation. Maybe just being in school is enough for this child to be released on bond. He's going to school. The school teacher can give us reports every other day that the child is in school. So bond may be the same, but of course the terms will differ, but the law just looks at everyone being equal. But the court will go into these other issues to see that the child has actually left. Because remember what we were told, the deprivation of their liberty is the last resort.
The last
so
resort.
You can't go to any length, all the lengths you can go to make sure the child goes home, to continue with school if they are in school, and continue their lives out there as their case is pending in court.
I think my key takeout for today is deprivation of liberty as the last resort. If there's an exam, that should be the first question for me today. Yeah. So, Carol, I just want to ask about culture. As you're coming up with the guidelines, did you consider culture? Are there some things in our culture that actually are child friendly? Because when you think about an African child, punishment was very fast. But are there things that were restorative about our culture when it came to bringing up children?
I think just the, like the African saying, it takes a village to raise a child.
Yeah.
I think that is the thing, and what we are saying as ODPP, that's why we have programs in the diversion guidelines and policy that encourage, taking the child back into the community and having the community continue with that raising of the child.
Yeah.
So I think that is really the most important. Sometimes people call it the ADR, the traditional mechanisms.
Yeah.
And they can be very effective. And like taking the child to court and putting them into an institution, when you take them back into the community they belong to and allow the community to just rehabilitate this child, they love the child, they accept the child even more. And sometimes children commit these offenses because they feel like they have been neglected.
They want attention.
They want attention. So when you take them back into that community and then they see the community really embracing them and being ready to give them a second chance, they never go back into crime. Yeah.
Quite interesting. I never imagined that our culture, because it's very, is it retributive? Could make
She can't hear us.
Did we lose the judge?
Yes.
I think it's the internet. Can you hear us?
Okay.
Technology.
Yes.
Yeah.
What happened?
Let's see. I have quite. So we'll just continue. We'll just, because we're about to wind up. I wanted to ask, in your opinion, what is a game changer with this guideline? What changes for you as a prosecutor?
It makes us more sensitive to these people that we handle every day, children. Yeah, because unfortunately in our work, day in, day out, we have to handle children. Most of us do not really understand how to handle these children when they're in the criminal justice system. When they're at home and they're thriving and they're good, we know how to handle them. But when they come into the system, because we make very life-changing decisions for them, what this guide is going to do is to ensure that we are making the right decisions for these children, that we are not becoming the second perpetrators against the lives of these children. So we are not taking them through secondary victimization by denying them their rights, by being the ones who are infringing their rights. For example, if you're proceeding with a child in a case and they don't have legal representation, you're actually being part of those who are infringing their rights to legal representation. So we are looking at making prosecution to be fit for children, ensuring that when we make that decision on the life of this child, that decision is actually going to build this child, make them better human beings, and then safeguard all their rights. So that's why we are very happy with this, and we are going to ensure that the child in Nairobi and the child in Turkana are both benefiting from the same standards of prosecution. Yes.
I'm wondering what is happening at the investigative level, at the police level, because I can't imagine their child-friendly cells. Because what I see here is a child-friendly judiciary, child-friendly prosecution. What happens before they reach here?
I know most government institutions might have challenges, and sometimes it is budgetary issues, the finances. So you have police officers very willing to give good infrastructure for children and handle them in a child-friendly manner, but unfortunately they might not have the resources. So everyone is struggling to just do what they can, but there are also police stations that have been able to set up like the CPUs, the child protection units within the police stations, to ensure that when they are investigating the matter and they have apprehended a child, the child does not stay in the adult cells. They're in a separate place which is sensitive to their, their gender and their age, and they have all their needs provided. Burubul police station has a CPU that even has a playground.
Oh, really?
Yes. So nice. Yeah, there are good efforts. Kamkunji, the other day, the CJ was in Kamkunji last week for the service month, the children's service month. And Kamkunji has a CPU within itself. Wow. So with good colors, just up here at the police station up here, I'm forgetting the name, they have the center, which is a one-stop center. For children. So police are also, trying their best. Yes.
Yeah, they're coming along. Then best picture of success is what? A full system that is child-friendly?
A seamless system that is fit for children. Yes.
Okay. And you can achieve that?
Yes, we have started, and very soon ODPP will be setting up 7 child-friendly interview rooms. Yeah, so we are talking about interview rooms that are child-friendly in the sense of environment. We have the child-friendly colors. We'll be having toys and storybooks, and a place where if a child comes and they are a victim of a crime, they can relax, and the prosecutor can be able to create a rapport with the child so that as they prepare them for court, the child can understand what to find in court, and the prosecutor is able to pick out, does this child victim or witness of mine require extra protection while in court? And then we'll also be installing video conferencing equipment in all of these 7 rooms. And just to mention, they will be in Nairobi, Mombasa, Kisumu, Nakuru, Tononoka, Lamu, Kajiado, and here in Kiambu. So the video conferencing, we want to move an extra. We want to take Kenya to the next level. So the DPP is looking at having a system, us having not to take the child to court. Because sometimes we have had psychological reports, mental assessment reports telling us, don't take the child through the system. I mean, don't take them in active court because it will be detrimental to their mental health. So video conferencing is provided for in the Evidence Act. We're still waiting for the CJ to set up the rules, but it would allow for a child to be able to sit in that child-friendly interview room, give their evidence in that child-friendly environment, with the evidence being linked into court. Yes.
So they don't have to go to court. Are you setting the standards in Africa? Are you the first in Africa to have this guideline?
The guideline?
Yeah.
Guideline, we are not the first. We have other countries that have it. Okay. But this kind of child-friendly interview rooms, I do believe will be the first in Africa. Yeah, so ODPP is really trying.
Okay. Yes. Keep soaring. I want to come to the end of this discussion, and I think we lost a judge. I don't know that she can hear us. I think we lost her, but I definitely will call after this to say thank you for her insights into this whole child-friendly system. We're also trying to understand it as a public, and maybe a lot of sensitization is needed so that we don't go pasting and copy-pasting images of children on social and sharing details about children. So a lot has to be done from, like you say, the system has to be seamless, and it's quite a journey. So thank you so much, Carol, once again. This topic is never exhaustive. You can never finish talking about children.
Very true.
Because clearly, kulea ndio kazi.
Yes.
Yeah. So thank you so much again for coming to the show, and we'll welcome you again to come and talk to us about how seamless the system has become. I mean, in a few months or maybe a year or so.
Yes.
And I wish you well.
Thank you so much.
All right. So thank you so much, everyone who joined us on YouTube. Thank you for joining us in this conversation. Like I said, it's never exhaustive. This is possibly the third time we're talking about children and the law, and there's still so much you can talk about. We had the judge on air on Zoom, and I think because of technology issues, we must have lost her. But she gave us some very good insights about their journey into developing guidelines as well as NCAJ. So once again, I want to thank you, and I want to welcome you again next week. Hopefully we'll be back on Facebook, and let's just join us to see exactly what we'll be talking about. Next week, I believe we'll be again with Carol in Garissa, talking about anti-FGM, and join us to see what's happening down there. Good things. I mean, when there are policy guidelines, and it means people know how to operate. So I don't know, Judge, can you hear us? She can't hear us. Yeah. All right. So I want to wish you a very good Friday, a warm one, and a good weekend ahead. Join us again next week and see our discussion on anti-FGM laws and the standard operating procedures that are going to be launched next week. God bless you. Thank you.